Welcome, everybody. Thank you so much for joining us today for our weekly webinar series. Today, we're going to be discussing navigating workplace challenges. Today's topic is mostly going to focus on bullying, harassment, and discrimination. A little bit about us. We are Achkar Law. We were founded back in 2016. We focus largely on employment law, human rights law, labor law. We do workplace investigations and civil litigation. We also have a growing commercial and corporate litigation group, and we serve all of Ontario. Actually, we serve all across Canada. Today's series is going to be hosted by yours truly. My name is Charles Miller. I'm a senior associate here with the firm. I'm joined by my friend and colleague, Mariel Gerges. She's also another senior associate here as well. What exactly is bullying, harassment, and discrimination? To understand that, the first thing to know is that as a workplace or as an employer, you have an active duty to make sure your workplace is free of bullying, harassment, and discrimination, which is understood a little differently in the workplace scenario as opposed to out in regular social setting. Bullying in the workplace center is seen as any sort of acts that are verbal, comments, physical acts that are meant to mentally hurt somebody or isolate them within the workplace. Sometimes bullying can also be physical, not just verbal. And usually it involves repeated incidents of this type of conduct, though sometimes even a single incident is enough to initiate a claim for bullying in the workplace. Some of the examples of workplace bullying you might see are spreading rumors about a colleague, or excluding them from social events, or if you have like a clique of people you like to eat lunch with, and then not letting, say, Matthew sit with you at lunch. That's not just schoolyard bullying, that's workplace bullying as well. Still just as hurtful. Any sort of comments with the intention of undermining someone's work, making them seem as inferior in the workplace, sabotaging them by hiding information, such as taking someone off of an email chain would be workplace bullying, or tampering with their belongings, going to their office and moving their photos around. That would be workplace bullying. That's typically colleague to colleague, but it also occurs employer to employee. These can be seen as undermining work performance, constantly telling them they're bad at their job when nothing could be further from the truth. Changing guidelines constantly. Again, employers are allowed to add and remove work as business needs change, but if you do it too frequently, it can be considered a little disruptive. Creating impossible deadlines or moving goalposts. If you give someone a task that takes 4 days to complete and you give them 12 hours to do it, that's bullying. And any sort of constant criticizing. As an employer, you have what's known as a due diligence, which is the standard to make sure that you root out any sort of bullying in the workplace and make sure this doesn't occur. You need to make sure you take the precautions to keep a safe workplace environment that includes bullying. Now, not everything is considered bullying. Having a difference of opinion won't be bullying, such as deciding who's the best football team. It's not bullying. Or constructive feedback. This is a tricky one because constructive feedback is perfectly reasonable and sometimes very healthy and important in the workplace. But as an employer, you have to be mindful. Is my constructive criticism getting to the point of now I'm just overly criticizing somebody? And as the employee, you need to watch that as well. A way to understand bullying is different from harassment and discrimination, as that bullying has this intentional component to it, whereas the person's intentionally trying to intimidate or undermine a colleague or an employee. Harassment is a bit different. You see, harassment, while it can also be intentional, can also be completely unintentional. So harassment in the workplace is engaging in any sort of vexatious comment or conduct against a worker in the workplace that is known or ought to be known reasonably to be unwelcome. This is an important standard. Workplace harassment can be blatant or more nuanced, as in harassment can be something you can identify right away, but sometimes harassment is something that you don't easily identify. Harassment can occur over a single day or may occur over weeks to months. Typically, when our firm receives a complaint about somebody saying that they've been harassed at work, typically it's been going on for weeks or months. That's usually the case. But even a single bad day of harassment will reach that standard. Now, I mentioned before that the standard for harassment is unwanted comments that is known or ought to be known by a reasonable person. This can seem very subjective, as in, what ought to I have known? What should I know? What does a reasonable person really know? It's a hard line, but generally speaking, in today's modern society, we take a much more liberal approach to that. And so generally better safe than sorry. When you consider comments that are known to be offensive, best to err on the side of caution. Don't say something you know is going to be offensive, even if you're doing it in a comedic sense. Sometimes comedians will say a joke that they know is offensive to get a laugh. Save that for the comedy stage. Do not bring that to the workplace because you don't know who your listeners are. And if they find it to be harassing, then harassment's occurred. And saying that someone should just have thicker skin isn't going to be a viable defense. We do take a much softer approach here in employment law in Ontario and across Canada, where if it could be offensive, it is offensive. It's happened. Now, what a reasonable person ought to know to be harassment is a lot more nuanced and can be a lot harder for employees and employers to identify. Sometimes an employer can be guilty of harassment and have zero intention of hurting anybody or causing offense, zero intention or understanding that what they've said could be a hurtful offensive, and they're still guilty of workplace harassment. You see, it's not a viable defense to say you did not think what you said would be offensive, because again, bullying is the aspect that has intention, not workplace harassment. You don't necessarily need intention for workplace harassment to occur. What you need to know is, would a reasonable person find this offensive? And that's harder to emphasize. We can talk about that ad infinitum. But today I'm going to kind of focus it into a sexual harassment context. Sexual harassment is one of the biggest occurrences that occur in modern workplaces. They tend to occur either intentionally or completely unintentionally, with people not realizing that what they've said is sexual harassment. Examples of sexual harassment that occur in the workplace are any type of flirting. Again, leave that for the bar, leave that for the dating app. The workplace is not really the place to go and start being flirtatious or extra charming to somebody. Making any sort of sexual solicitation, inviting someone back home or asking to go over to their place. Don't do that in the workplace. That's not the place to do it. That's sexual harassment in the workplace, especially if you hold a position of authority. You see, employee to employee flirtations, there's a bit more wiggle room in understanding, was this unwelcome attention? But employee to employer or employer to employee, because of the power imbalance between the two, employees can't really consent to this type of attention. And they might feel the job's on the line or their career advancement's on the line. So better safe than sorry, don't engage in it at all. Any sort of touching, such as hugging or rubbing someone's back, again, that could be raised level of sexual harassment in the workplace that some people might not even think. You're just hugging someone to say hello, but in workplace context, that could raise the level of workplace sexual harassment. Something else to consider as well, or a way to put this into context, not everything's going to necessarily raise the level of sexual harassment. Context does matter. So for instance, if someone walks in that day and they look nice, telling them that their hair looks nice that day, not necessarily going to raise the level of sexual harassment. If someone walks in looking nice and you say, hey, you look hot today, that's going to be some sexual harassment. Also, tone and body language matter. If you tell someone their hair looks nice, but there's something about the tone of your voice, your body language, or what you're saying that conveys a more nuanced attention behind your comment, it could raise the level of sexual harassment as well. Context matters. What you're saying matters. If a reasonable person would find it unwelcome, don't do it. Another issue that we might see often that might raise to the level of harassment is asking someone what their ethnicity is. Many people, and I've had clients before approach me, accused of harassment in the workplace for this comment, saying that I didn't intend to offend, I was curious. Well, being curious is unfortunately not a viable defense in a harassment claim. You see, whereas your intention doesn't matter either. What matters is what a reasonable person find that an unwelcome statement. And what courts and modern day employment law see is that if you ask someone that, you are treating them as different, pointing out something about them racially or the color of their skin, treating them as different, identifying something about them. Sometimes historically has been seen to be almost flirtatious in a way, treating them like they're exotic. Someone receiving that comment could feel harassed, could feel differentially treated, It could be even discriminatory in nature. So be mindful about what you say or do in the workplace. Marielle's going to touch base a lot on that topic later, so I'm not going to go too much into that. But it leads into discrimination as well in the workplace. Discrimination in the workplace, whereas bullying and harassment seem to be a little bit more broad and generic, discrimination actually usually can be understood as targeting an aspect about the person, such as their age, their religion, their sexual identity, their family status, something about them that is captured under the Ontario Human Rights Code protected grounds. Any sort of differential treatment towards somebody based on a protected grounds would be considered discrimination in the workplace, with some allowances, which Mario will get into. But when you're in the workplace, and if you're an employer, you need to make sure that your workplace is completely free of any discrimination on protected grounds, completely free of harassment, completely free of bullying, for many reasons. The effects of bullying, harassment, discrimination in the workplace are quite detrimental. We've known since the 18th century with philosophers such as David Hume that the pride and importance of someone's work is extrinsically related to their sense of self-worth, such that any sort of stress or encumbrance or harm or harassment they experience in the workplace can be arguably far more damaging to a person's sense of self-worth than if it occurred in a social setting. So people could have health-related issues if they experience this type of discrimination. Stress is a major part. If you are being discriminated in the workplace, you're going to experience that level of stress. Stress is not just mental in terms of the psychological well-being. Stress impacts your physical well-being as well. Scientists have uncovered that stress is linked to digestion. You might gain or lose a bunch of weight if you're experiencing high levels of stress. You could lose a lot of sleep, have trouble falling asleep, and your immune system could be compromised as well, leading to further illnesses. Health and the impact that harassment plays on health is very important in understanding workplace harassment, because if an employee later decides to bring an action against an employer for workplace bullying and harassment, there is a head of damage known as aggravated damages, we'll just touch base on in a moment, which talks directly about how the person or the employee was personally impacted by the harassment and how that physically impacted them, and seeking additional damages should they bring the claim. And bullying and harassment links directly to an employee's job satisfaction. As an employee, if you're experiencing harassment and bullying in the workplace, you're going to hate your job. You're going to feel like what you're doing is not very good enough. You're going to feel hurt. You're going to feel like your career's not going anywhere. And chances are your personal output will decline. And chances are you also might not even stay with the employer. And employee retention leads directly into constructive dismissal. Constructive dismissal are claims where the employee has resigned, but has made the allegation that I did not want to quit. I was forced to quit because of the discrimination or the harassment and the toxic workplace environment I experienced at that workplace. Therefore, the employer is responsible for paying me reasonable notice plus other heads of damages. You see, normally when an employee quits and resigns, you don't pay them anything. They're not owed any entitlements. They go their separate way. No hard feelings. Constructive dismissal, though, is they're alleging they were forced to quit. They're going to bring a whole argument about the toxic workplace, and that claim goes against the employer. Because as I said before, it's the employer's responsibility to keep their workplace safe. And even if the employer is not the one harassing, if it's like another colleague at work or someone else there, the employer has an active duty to keep the workplace safe. And if you don't do that, the employee will likely have a claim for constructive dismissal against the employer. That not only includes damages of reasonable notice under common law, which if you've seen our other webinar series can be quite substantial, but you include other headed damages such as the aggravated damages I talked about for the personal suffering they experienced. You could also see punitive damages, which is the court saying that they're so offended by the conduct of the defendant, or the employer in this case, for this abusive environment, that they want to punish them further at additional damages. Plus, you might see claims under the Human Rights Code wrapped up in the civil claim for any sort of instances of discrimination that occur. So as you imagine here as an employer, a constructive dismissal claim can be quite problematic, quite substantial. And the desire to keep a workplace safe is not only legislatively bound, but also there's an interest there in making sure that your company is safe and not liable to these types of damages. And to talk a bit about the legislation surrounding workplace bullying, harassment, discrimination, as well as what employers and employees can do in these circumstances, I am going to toss this over to my friend and colleague Marielle, who's going to go into more detail about all those topics.
Thank you, Charlie. Charlie's done an excellent job here about outlining what discrimination, harassment, and bullying actually are. Let's get a little bit into the law here. So I'll talk about the Human Rights Code first. So under the Human Rights Code, there's going to be a few sections that are pretty relevant for employers and employees. With respect to discrimination, every worker has the right to equal treatment with respect to employment without discrimination. And Charlie mentioned there's a couple of code grounds. Let's get into what those actually are. Race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, age, record of offenses, marital status, family status, or disability. So essentially, a worker, even during the hiring process actually, cannot be discriminated or treated different or poorly because of any of those grounds. And as Charlie mentioned, discrimination can actually take various forms: unequal treatment, denial of certain workplace opportunities, disciplinary action, or even termination. But as with everything in law, there are always exceptions. So the exceptions under the Human Rights Code are pretty narrow. For instance, the right to equal treatment is not considered violated when the reason for that different treatment or the discrimination is due to the reasons of age, sex, record of offenses, or marital status, and that factor is a reasonable and bona fide requirement because of the nature of the employment. So to use a very trivial example, if someone was found guilty of committing financial fraud, they might not be hired in a major bank as a financial advisor because that position, as part of the requirement of the job duties, there's a certain element of trust that the person's going to be handling a person's finances honestly, and several counts of financial fraud kind of goes to the root of the employment in that example. Under the Human Rights Code, workers are also provided a right to freedom from harassment as well in the workplace based on one of those grounds. So general harassment is not covered under the Human Rights Code. It has to be linked to one of the code grounds. So using Charlie's previous example, if the curious colleague keeps asking another colleague about the race of that individual several times, that might amount to harassment on the basis of race. Sexual harassment is also covered, so workers do have the right to be free from sexual harassment in the workplace. And the Human Rights Code goes a little bit further and protects employees from something known as reprisal. So reprisal is a consequence someone faces for standing up for their human rights. So let's say, for example, John is facing age discrimination from his colleague. John then makes a complaint to either HR or his supervisor. The next day, HR fires John because of the complaint he made. So this is a pretty clear example of reprisal because John was terminated as a direct result for standing up for his human rights. When we talk about discrimination, particularly we see this most in the disability context, employers also have an obligation to accommodate employees to the point of undue hardship, which is just as strict as it sounds. The Human Rights Code says when we're talking about undue hardship, we have to consider cost, outside sources of funding, if any, and any health and safety requirements as well, if applicable. But an employer is saying, buying that ergonomic chair for an employee with longstanding back issues is expensive, likely won't be enough under the Human Rights Code. The employers have a very strict duty to accommodate its employees to the point of undue hardship. But at the same time, employees do need to engage with the process and make it clear, this is what I'm facing, not necessarily a diagnosis, but an idea of how the employer can actually accommodate the employee. And generally, the process is very fact specific. So we would recommend pretty early on in the accommodation process, get a legal advisor involved, whether you're the employer or the employee, just to make sure things run smoothly. And under the Occupational Health and Safety Act, employers have a duty to provide a safe working environment to its workers. And workers under this act actually has a very wide definition. So it includes individuals such as contractors as well, or subcontractors. Employers are required to investigate harassment complaints, regardless of what they think about its merits. So the employer must actually notify the complainant and the alleged harasser, assuming it's a worker of the employer, about the investigation results in writing and whatever corrective action that has already been taken or will be taken moving forward. Same with under the Human Rights Code, under the Occupational Health and Safety Act, the employer cannot discipline, suspend, threaten to discipline or suspend, intimidate, coerce, or penalize an employee for filing a complaint under this act. So the Occupational Health and Safety Act does include reprisal provisions as well. So it protects employees' rights as well as the right to complain about the infringement of those rights as well. With respect to the Occupational Health and Safety Act, employers regularly employing 6 or more workers must have written workplace policies on violence and harassment. They're also required to regularly update them and post them where they can be seen in the workplace. And this is a great tool for employers to prevent misconduct for a number of reasons. It lays out their expectations. It can also help deter misconduct and lay out procedures for how employees should report any alleged misconduct. So it's one of those great tools that A, is a requirement under the act, but can also help an employer avoid future issues as well. What can you do if you suffer bullying or harassment or discrimination in the workplace? First, report the issue. And this is going to tie into gathering evidence as well. It's extremely important to record the details of each incident. Note down the date, the time, the location, where in the workplace did this happen, what actually happened, who said what, when. And we always recommend sending a report like this in writing, either to your supervisor or HR, just so everyone has a copy of what was actually said. In your account, set the scene. Who was there? What role did they have? Are they a supervisor? Was it the director or CEO? Did your supervisor or anyone else witness what happened? Did anyone come and talk to you after the incident? So, for example, if a colleague said, hey, I heard that comment, I don't think that was very appropriate, write that down. Write down who said what to you and when. We also recommend documenting the effects that the mistreatment actually has on the employee, both during and off work. Charlie hinted to this as well. There's essentially scientific studies that have come out to say the effects that stress has on the body, it does a lot more than just affect an employee in the workplace. For instance, it might take an employee's focus away, but it might also affect their appetite during and after work, sleep quality, which then impacts every other part of their lives. So keep a note about what's happening when. Did any of your colleagues change their dynamic with you afterwards? After you filed that harassment complaint, did your boss start giving you the cold shoulder? Or did you start becoming micromanaged? Keep a record of any differing treatment and build that record moving forward. Even document things like your initial report to your supervisor or HR. If an incident happens and you walk straight into HR, have that verbal conversation, but afterwards, write down, this is what I said, this is how HR responded. They mentioned they would investigate. Did you have to keep following up with HR? If so, keep a record of that as well. In terms of gathering evidence, correspondences, emails, letters, text messages, witness statements, any employer's policies or documents, medical evidence, all of that's going to be relevant if you choose to take the next step. One of the options that you might have, depending on the treatment that you face, is actually going through the Ontario Human Rights Tribunal. So this is available for workers who face discrimination or harassment based on one of those specific code grounds we talked about earlier. So in terms of time limits, it would be 1 year from the last discriminatory event to file an application. But one thing to keep in mind is the tribunal only deals with human rights issues. Most applicants ask for 2 specific remedies. The first is general damages. This is tax-free compensation for injury to your dignity, feelings, and also to compensate for human rights violations. It's the remedy for the emotional harm that was suffered by the discrimination or harassment that you suffered. Same with special damages, which is the second most common remedy. It is meant to compensate financial loss directly linked to the discrimination or harassment, such as lost wages or other expenses. The other avenue that might be available to you is through Ontario Superior Court. So general damages are generally available through civil courts, such as the Ontario Superior Court, and if the plaintiff or the person who's starting the lawsuit includes other claims. So they don't have the authority to look after only human rights violations, but for instance, if there was a share dispute or a wrongful dismissal along with a human rights violation as well, Superior Court might be the most appropriate avenue for you. But of course, the best avenue on your case is really going to depend on the unique circumstances of your situation. So we always recommend at least booking a consultation with one of our experienced and talented lawyers so we can discuss pros and cons, which best avenue is available to you, and what you should do next.
All right. Thank you for that, Marielle. So we do have some questions that are submitted. The first one's an interesting one. As far as bullying is concerned, what if a female employee overheard her boss making fun of her lack of skills using a software program? The boss is specifically laughing with another male employee behind closed doors. Is this evidence enough to provide some sort of discriminatory claim? What would you say about that?
I would say that might be enough to constitute bullying and harassment in the workplace. Under the Human Rights Code, if we're talking about things like skill set, it may flow outside of that work environment, but generally what we find is where there's one issue in the workplace, there might be several. So at that point, I would say start documenting things like, for instance, what training did you receive for that software? Are those colleagues treating you any differently moving forward? I would also report the fact that you overheard this conversation and see what steps could be taken within the workplace.
Very good. Another question. In my former workplace, harassment complaints are to be resolved within 1 year, service standards. What happens if the employer, I'm assuming that's a service standard within the company itself. And what happens if the employer goes beyond that time, that it takes longer than a year to resolve it? Can that be held against the employer?
That could be seen as a breach of its own policies, but I would take a look and see what's actually gone on within that year. Have any steps been taken, or are they just about to resolve the matter? Is it heading to arbitration? So the steps taken are going to either aggravate or mitigate the factors that are going on here. If it's a matter of there's going back and forth with counteroffers, it may be that there's no recourse available, but at the same time, it's going to be very fact specific. If you spent 11 out of the 12 months following up with your employer and they're dragging their feet the entire time, yes, likely that's going to be an aggravating factor to what's been going on.
Thank you. I have another one here. Is this a form of discrimination where we have a female employee was not included in a company golfing function, and she was not provided with any company swag, such as a hat, jacket, cell phone charger, but all the male employees were provided with this swag. And the same employee was denied a cushion for sitting outside, also refused to provide an ergonomically appropriate chair. Would this constitute any sort of bullying or discrimination?
It may be seen as bullying and discrimination, given that it sounds as though this is a very male-dominated workplace, and the male colleagues are receiving benefits and benefits that the female colleague is not. At that point, I would start recording exactly what's happening when, and reporting the differential treatment to either a supervisor or HR, whoever you would feel comfortable reporting that the differing treatment to. I would also take a look and see whether things like missing swag or differential treatment at events, if that's the only time that that employee is receiving that differential treatment, or for instance, is there denial of other employment opportunities, and start building that record of the fact that this workplace may be treating its female colleagues poorly.
Can I fire an employee for constantly making frivolous and untrue harassment complaints?
That is a very tricky one. It's going to have to be framed in a way where the employer is not also giving that employee room to argue that there's been reprisal. So I'd want to take a look and see what are the complaints being raised and what has the employer actually done to address those complaints as well. It could be that there's something else going on and the employee simply doesn't know how else to bring it up. But I would say the immediate risk in that situation would be opening the employer up to being, giving that employee room to bring up reprisal as well, because terminating an employee in the sequence of several complaints seems as though the employer might be penalizing the employee for filing those complaints in the first place. So the best advice I could give is reach out to our office so we can give some more specific advice and take a look at what the complaints are that are being filed.
Very good. Thank you very much. That is all the time we have today. Thank you so much, Marielle, and thank you so much to everybody who attended today. We wish everyone a wonderful day, and I hope everyone has a wonderful afternoon. We'll see you again next week.